Hare Krishna. Welcome to TaxGuru YouTube channel. This is CA Rohanar, a practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series on GST Disputes Practical Aspects. And today we are going to discuss principles of evidence. So let's dive into it. Let me allow to share my screen. Yes. So in last session, we have discussed general principles. And now today in this session, we will learn principles of evidence. So what will be the key learning areas of the session? Evidence, documents, BSA 2023 Act, facts, relevance of electronic records, burden of proof, degree of proof, timing of evidence and expert advice, privileged communication, and affidavits. Let's see what is meant by evidence. Legal rights, liabilities, and duties are determined on the basis of evidence. So burden of proof lies upon him who affirms and not he who denies. Very important. Burden of proof lies upon whom? Who affirms and not he who denies. So it is nothing but by which facts are established to the satisfaction of person inquiry. So in the context of the litigation, evidence means litigation may be on account of dispute of chargeable to tax any transaction or dispute relating to claim of exemption or claim of input tax. So Bharatiya Sakshya Adhiniyam 2023 BSA categorized the evidence into two types, that is oral evidence and documentary evidence. Oral evidence, that is statement made before court by a witness, and documentary evidence, that is include electronic records, all documents produced for inspection of the court. Moving further, let's talk about documents. So it means any matter expressed or described by means of letters, figures, or marks. Example, writing, word pads, then lithography or photography, map or plan, then inscription on a metal place or stone, that will be also a document, caricatures. So at any stage of inquiry, claim for non-taxable or for exemption must be supported by with a verifiable proof. That proof be termed as evidence. So let's see BSA 2023. So evidence need to be kept in mind. Our undisputed facts do not require what? Proof. One who asserts needs to prove the correctness of that. So onus of proof may shift based on the pleading by either side. Information contained in the books of accounts are what? Not reliable source of evidence in the absence of corroboration. So example, what where service provider claim that his services qualify as experts, then he required to substantiate that particular fact. Moving further, let's understand facts. What is meant by that? So three types of facts there. That is first fact, relevant fact, and facts in issue. So what is meant by fact? So man heard or saw something is what? Fact. Certain objects arranged in a certain order in a certain place is what? A fact. Then relevant fact, when one is connected with other in any of the ways, then it is said to be relevant fact. And facts in issue means it means and includes any fact from which the existence, any right, liability asserted or denied in any suit or proceeding is what and facts in issue. Let's see BSA 2023 Indian Evidence Act 1872. So BSA 2023 replaces Indian Evidence Act 1872. However, the law is same with addition of certain aspects. So relevance of electronic records, right? So as per IT Act 2000, electronic records means what? Data, record, or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. So subject to certain conditions, electronic record will be admissible as evidence. Very important. So Evidence Act also provides what? Manner of verification of digital signature, presumptions as to the electronic agreements and gazette. Moving further, burden of proof. It is always on the person who alleges. So once such burden is discharged, the onus shifts to the other party. So under tax litigation, burden to prove that the classification adopted by the assessee is wrong is always on whom? The department. So whereas in case of claim of exemption, the burden shifts on who? Assessee to prove as to why and how he is eligible for the exemption. So supplying of sufficient evidence for claim of classification and or exemption will support the case and the deciding authority. So that is the importance of the burden of proof. Degree of, so extent to which the fact shall have to be proved. In case of criminal matters, proof shall be beyond the reasonable doubt also. In adjudicating proceedings, such degree of proof is not necessary, is what tribunal held. So adjudication proceedings determined on the facts and circumstances available in the particular case. Timing of evidence, very important. So right from the stage of investigation, assessee shall have to provide what? Evidence. So adducing evidence at the stage of adjudication proceedings with respect to show cause notice is very important. So new fresh evidences may be rejected by the appellate authority or tribunal as per rule 112 of the CGST rules. Expert advice. So opinions of experts may be relevant under tax litigation. So if assessee taken certain legal position based on the expert's opinion, then it would be relevant to defend the case. So that need to be adduced. Admission of certain facts in the statement or during investigation. So facts need not be proved by the department where those facts are admitted by the taxpayer or assessee during any inquiry or investigation. Means once those facts are admitted, then department need not to be proved that particular facts. Silence doesn't establish what? Guilt. So one who makes the allegation bears what? The burden to prove. Statements made on oath are presumed to be made what? Truthfully. So state is liable to refund the amount that has been collected unlawfully. That is also important to note. Privileged communication. So no, very important. This part is very important. No advocate shall at any time be permitted except with his client's express consent to disclose any communication made to him in the course of the proceedings. This is applicable to all the professionals. So provisions of section 132 subsection 1 and subsection 2 of BSA 2023 as above shall equally be applicable to the interpreters and the clerks or the employees of the advocates too. And that is also applicable to the professionals who are dealing in the proceedings. So no one shall be compelled to disclose to that court any confidential communication which has taken place between him and his legal professional advisor or legal advisor, that is professional or legal advisor. So very important to understand this privileged communication. So disclosure of information of client obtained during the professional appointment is what? Misconduct. It treated as misconduct as held by the High Court in case of Council of Institute of CA versus Mani S. Abram, Kerala High Court 2012. So however, it should be noted that the above privilege would not apply to communications leading to illegal activity or committing a fraud, etc. So that also need to be understood. Means many times we need to also inform or intimate that particular communication, but when that should means the in case of it leading to illegal activity or committing a fraud. In that we need to disclose. So pleader means any person entitled to appear and plead for another in court is what called as a pleader, and includes an advocate, a vakil, or an attorney of the High Court. Appearance by CA before any adjudicating or the appellate authority or the tribunal will not amount to appearance before any court. Immunity under Section 132 of BSA 2023 will not be available to the communications between said CA and his client. So now moving on the last part of the today's session, affidavits. So these are what written statements of the facts. So voluntarily made by an affiant under an oath shall contain what facts and grounds and not interfere, not inferences or submissions. So there are conflicting views on this particular affidavits part, that the aspect as to whether affidavits in themselves are evidence in the court of law or not. So that's questionable, and that is a interpretative. So that's it for today. Thank you. Thank you so much for patient hearing. If you have any questions, observations, suggestions, then do let me know via WhatsApp, email, or you can also comment below the video. So if you have not yet subscribed TaxGuru YouTube channel, then do subscribe for a latest updates and video series like this, which we are conducting on a TaxGuru YouTube channel. So stay tuned to the TaxGuru YouTube channel. Thank you. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.